Okay, there we are. Welcome to this 13th lecture in our animal rights law course. Last week, Sean discussed with you some of the first and arguably most prominent cases in animal rights law, the cases on habeas corpus, so lawyers trying to convince courts that animals have some sort of autonomy that is worth protecting, and that means that courts should say that wherever they're being held captive, that this is illegal and that they should be moved to a sanctuary. So those were the habeas corpus cases we looked at, and as we saw, only one or two of them were successful. Today we want to look at two different sets of cases that go beyond habeas corpus. So the first type of cases beyond habeas corpus is what I call fundamental or thick rights cases. Now, habeas corpus itself talks about the right to bodily autonomy, for instance, or the right to bodily integrity. So there is a fundamental rights component in habeas corpus too. But as we'll see, there are some cases that just talk about different fundamental rights: right to life, right to integrity, and indeed right to liberty as well, but independently of habeas corpus. So we're going to have a look at those. And then secondly, there are some cases that focus particularly on legal personhood or legal subjecthood. Again, here the division isn't a sort of a sharp, a very clear one. So as we'll see, the legal personhood cases also touch on some fundamental rights, and habeas corpus was also partly on personhood, as you will recall. However, there are still some that just where legal personhood is more salient, so we want to focus on these as well. And we'll end with a few conclusions as usual. Okay, now, why has there been an attempt to go beyond habeas corpus in the first place? Now, as I just indicated, habeas corpus litigation has arguably been the most prominent type of litigation in animal rights so far. That is, if we exclude the whole, welfare litigation, of which there is, of course, a lot. But focusing on fundamental rights of animals, habeas corpus is where there's the most action, if you like. But not everyone's been particularly happy with these habeas corpus cases. And there have been roughly two critiques or criticisms that have been put forward against those habeas corpus suits. The first one is that habeas corpus only manages to focus on a quite narrow set of rights, right? Because of the nature of what habeas corpus is, the idea that an animal is being held captive and it needs to be moved to a sanctuary or be freed entirely, you will only be engaging with essentially the right to freedom, the right to bodily autonomy, perhaps. But you can't really go beyond that just in virtue of what habeas corpus is supposed to do: free someone who is being held captive illegally, right? So there's quite a narrow range of rights that you can invoke. The second constraint of habeas corpus is related to that first one, and that's the fact that if you're pursuing habeas corpus, you're going to focus on quite a narrow range of species, namely the ones that have that kind of autonomy that is necessary for them to have an interest in not being held in captivity, right? Now, arguably, perhaps, quite a few species might have that autonomy, but the Non-Human Rights Project and other lawyers who've been pursuing these habeas corpus cases have been finding that the argument can only be made very compellingly, say, in the case of elephants or chimpanzees. So quite a narrow set of species. Thanks, John. Okay, so these are quite some constraints, and that's why we're seeing two other types of cases emerge, as I suggested, cases focusing on other types of fundamental rights and cases focusing on animals' legal personhood or legal subjecthood, the two terms being sometimes used synonymously. Let us start now with the fundamental, or as we've been calling them in this course, thick rights cases. Specifically, the rights that have been litigated most often are the rights to life, to integrity and liberty, and we're going to have a look at these different rights in courts around the world. I want to start with this case here, Animal Welfare Board of India versus Nagaraja. I'm not entirely sure how to pronounce it. I hope that's correct. This is a case from 2014. What happened in this case exactly? This was a case that made its way through the Indian court system because of a legal action that an independent NGO called Animal Welfare Board of India, so this is not a public authority, this NGO brought this case, and it asked the courts, and went all the way up to the Supreme Court, to determine whether so-called Jallikattu races violate the Federal Prevention of Cruelty to Animals Act, so the Federal Indian Animal Cruelty Act, or Anti-Cruelty Act. What are Jallikattu races? You get a sense of what they involve on this picture here, which I've taken from the internet. Essentially, they involve bulls or bullocks being chased by a group of people, usually men, who try to basically catch the bull, pull them down. And quite often this involves harming the animals, and at times it also led to the death of some of these bulls and bullocks. So this was being challenged in front of the courts on anti-cruelty grounds. The Supreme Court found that indeed these races, which take place only in certain regions of India, do indeed violate the anti-cruelty provisions and the Act's limited welfare provisions. This is basically just a welfare judgment so far, so you might ask, why are we discussing this? Didn't we just say we're going to talk about rights? And that's where this invocation of Article 21 comes in as being particularly interested. So the Supreme Court said, okay, there's this welfare stuff, you're absolutely right, there's a violation of that. But there's something more going on here. And what's Article 21 of the Indian Constitution? It's the Indian Constitution's right to life provision. Right? So the Constitution here says in this article, no person shall be deprived of his life or personal liberty except according to procedure established by law. And now comes a very interesting consideration. This is from the judgment itself. So the court says, every species has a right to life and security. Right? But they don't say here, human beings have a right to life only. Every species has a right to life and security, subject to the law of the land, which includes depriving its life out of human necessity. I'll come back to this point. And then court goes on to say, Article 21 of the Constitution, while safeguarding the rights of humans, protects life, and the word life has been given an expanded definition. Right? So we're not talking just narrowly humans' right to life. We're talking about an expanded definition of the word life. Court goes on to say, and any disturbance from the basic environment, which includes all forms of life, including animal life, which are necessary for human life, fall within the meaning of Article 21 of the Constitution. So, including animal life. Court goes on to elaborate this somewhat, saying, so far as animals are concerned, then, in our view, in the judge's view, life means something more than just the mere survival or existence or instrumental value for human beings. It also means leading a life with some intrinsic worth, honor, and dignity. Right? So talking about the constitutional right to life provision of humans, you would think, the court starts talking about how life needs to be interpreted more broadly, as also including the right to life of other species, and of how life needs to be seen as something broader than just not being harmed or treated cruelly, as in the case of these Jallikattu races, but indeed also as something more positive, if you like, something more expansive, a life with intrinsic worth, honor, and dignity, more than mere survival, worth, honor, and dignity. So what the court seemed to be doing then here is, it seemed to imply that the right to life could also protect non-human life. The constitutional right to life could also protect non-human life. But there's some problems with this implication. It's not really clear whether this is exactly what the court meant. The judgment leaves a lot of room for interpretation. Specifically, and this takes us back to the little section that I said I would come back to earlier, which said that, yes, every species has a right to life and security subject to the law of the land, but this includes depriving life out of human necessity, right? So this is quite an important caveat to add to the provision that animals have a right to life. Yes, they have a right to life, but we can kill them out of human necessity, right? Which seems to suggest that, well, are we now just back at, square one, where animals can be killed for human necessity, as they can in all other jurisdictions around the world, right? So this little caveat here really seems to undermine this general message that every species has a right to life, or at least there's ways of being perhaps slightly more pessimistic about this, the initial reading that I proposed earlier about there being a right to life for all species. Now, what you're seeing here is something that is going to be repeated in the other cases that we'll be discussing. You're going to be seeing courts using quite flowery language, sometimes quite promising language, that can, however, be interpreted in different ways. And the courts don't really resolve the potential tensions that they introduce in these promising paragraphs, right? So here we are left wondering, did the Indian Supreme Court really recognize the right to life of animals? Or did it perhaps rather say that their lives are worth protecting, but at the end of the day we can still kill them out of human necessity, suggesting that even if they have a right to life, it might not be as strong as humans' right to life. Okay, let's move to another case here. This is the case of Kaivan, the elephant. Kaivan was an elephant kept in a zoo in Islamabad in Pakistan. You see Kaivan here on this photo. An action was brought to the Islamabad High Court, so the regional High Court, on behalf of Kaivan, as well as other animals living in the zoo. The focus is usually on Kaivan because it's such a charismatic animal, but there were other animals involved too. Interestingly, this was a case that asked for Kaivan and the other animals to be moved to a sanctuary, but it was not a habeas corpus suit, so they didn't invoke habeas corpus, but ultimately they were looking for something quite similar for the animals to be released from their captivity, if you will. What did the Islamabad High Court decide? It's quite an interesting judgment. In case you've already read it, you will have noticed that it draws on really a very broad range of sources. It goes into religious texts, from Hindu texts to the Quran, and how life of animals is respected and accorded some worth, some dignity in these sources. It looks into foreign case law, a very wide-ranging judgment. And after all of this, the judge then does indeed order the relocation of Kaivan and the other animals to sanctuaries. So, though this wasn't a habeas corpus suit, it did indeed achieve something very similar. But interestingly, for our purposes, the judge didn't just order the release of the animals to the sanctuary. The judge specifically asked the question whether animals do have legal rights, and they answered that question, saying, without any hesitation, they do have legal rights. The answer is in the affirmative. But that leaves us with the question, well, which rights exactly do they have? Is the judge just talking here about thin rights, potentially? Are they really, suggesting that animals have certain thick rights? Here's a paragraph from the judgment, where the court says, animals have natural rights. A very interesting choice of language, right? So suggesting rights that animals have even before society exists, potentially, right? Even before they're recognized in positive law, animals already have these rights, moral rights, perhaps you might say also, which ought to be recognized in law. It is a right of each animal, a living being, to live in an environment that meets the latter's behavioral, social, and psychological needs. It is also a natural right of every animal to be respected because it is a living being possessing the precious gift of life. Okay? So the court here, it was actually a single judgment, and drew explicitly on the Nagaraja case and how the Indian court, the Supreme Court, had recognized the right of life to animals, or at least seemed to be doing so. This judge thought they had. And it does something similar. It talks about how life requires more than just not being interfered with. It involves, for instance, having an environment that meets one's behavioral, social, physiological needs. It's a precious gift of life here, the judge says. Now, despite all of this, the judge did not declare that animals have a fundamental right to life in the strict sense. Right? Again, there's a lot of sort of nice-sounding language, but then the judge doesn't quite, get themselves to declaring that animals have a right to life. Instead, they adopted an interesting alternative, sort of indirect approach. They said, well, if you think about it, without the wildlife species, there will be no human life on this planet. It is therefore obvious that neglect of the welfare and well-being of the animal species, or any treatment of an animal that subjects it to unnecessary pain or suffering, has implications for the right of life of humans, right? So what the judge is doing here is they're trying to say, okay, it might be a bit of a stretch to say that animals, at least, as the law stands currently, have themselves a right to life. But humans have a right to life, clearly. And we could argue that protecting animals, as part of protecting the environment, protecting nature, serves the right of life of humans, right? Because they have an interest in living in a healthy environment, say, if you think about COVID, where animals, too, are healthy, right? Because otherwise it could affect the lives of humans. So it's an indirect solution, if you like, an indirect path chosen here. We talked about it 2 weeks ago, about a similar solution adopted by the Romanian Constitutional Court, saying, well, the Romanian workers having to kill so many stray dogs, their right to dignity would be infringed, right? So you have an indirect protection of the animals through a human right to dignity in the Romanian case, to life in the Keivan case. Okay, let's move to another interesting case that I was a bit more involved in personally. So this is the Swiss primate rights case. You'll recall from previous discussions we've had that there's been an initiative, or was an initiative that was launched in the Swiss state, the Swiss canton of Basel City, which proposed to amend the constitution by triggering a referendum, and the constitutional referendum would have introduced a fundamental right to life and bodily and mental integrity for non-human primates. It would have added this to the existing list of fundamental rights held by humans. Now, the local authorities, the local parliament and local executive, they didn't like the initiative very much, and they thought that it violated federal law. For an initiative to be put to the people, it needs to be legal. It cannot violate federal law or indeed other law. And therefore, the courts had to deal with this question, well, is the initiative legal or not? A case went up all the way to the Swiss Federal Supreme Court, the highest court of the land, which specifically had to rule on this question, whether this initiative was indeed constitutional, whether it complied with the federal constitution. What did the Supreme Court find in this instance? It followed a previous ruling by the state's, the canton's highest court, the Cantonal Constitutional Court. And that court had found that absolutely cantons can, if they want to, create additional fundamental rights in their constitution for animals. The only restriction we are going to add to this is that for this to be in compliance with federal law, these fundamental rights could only bind public bodies. So, for instance, the state university, the state hospital, other public bodies. They could not, however, bind private citizens. So if you were a private citizen in the canton of Basel City, you could still have your own chimpanzee, if you liked, as long as you kept that or treated that chimpanzee in conformity with the Swiss federal welfare provisions. The Supreme Court agreed, and interestingly, it said that against the counter-argument that was raised, counter-argument went, well, look at the Swiss Civil Code. The Swiss Civil Code is the code that lists the different kinds of legal persons that exist. It talks about natural persons, i.e. human persons, human legal persons, and it talks about corporations. It doesn't talk about animals, and therefore this exhaustive list means that you cannot give fundamental rights to primates because legal personhood is a necessary requirement to have fundamental rights, and animals cannot be legal persons, according to the Swiss Civil Code. This is quite interesting because the Swiss Civil Code focuses on having rights and duties, right? You'll recall that there's some interpretations, sometimes social contract-based interpretations that say if you want to be a legal person, you have to be able to have rights and duties, i.e. you can reciprocate duties. Interestingly, the Supreme Court rejected this argument. And it said, well, while this may be true of the Swiss Civil Code, we're not talking about private law here, civil law here. We're not talking about chimpanzees needing to contract with someone, right? We're talking about fundamental rights law, which belongs to public law and not to civil law or private law, if you like. And it's very well possible that non-human primates can be considered legal persons for the purposes of public law, fundamental rights holdership. It's quite interesting here, the court didn't say it in so many words, but they seem to be introducing different notions of legal personhood. Public law legal personhood, private law legal personhood. And they didn't take issue with the idea that some animals could have rights. Don't forget, this was just a decision on the legality of the initiative itself, right? So the court did not rule that these animals would now have all these rights. And indeed, the court's ruling did pave the way then for the vote on the rights of animals in the canton. This happened, in fact, last week on the 13th of February 2022. Rather unfortunately, only around a quarter of the population were in favor of the initiative, so it got rejected. It's off the table for now. So perhaps rather ironically, the Supreme Court ruling that wasn't really intended turned out to be maybe the biggest success of this whole initiative, not the initiative itself. Okay, so we had right to life, we had right to integrity, bodily, mental integrity. This case here, again from India, talks about the right to liberty. Right? So yet another fundamental right. This is People for Animals versus Mohatzim from 2015. What were the facts of this case? Another animal welfare or rights NGO, People for Animals, brought a legal action against a businessman, basically a trader, who had lots of birds, I think thousands of birds in small cages in their apartment. They kept them there in the same way as maybe a bookseller would have books, that they then brought to the market to sell. The Delhi High Court, in this instance, had to decide whether this trader, this bird seller, violated, again, the Federal Prevention of Cruelty rules, the anti-cruelty rules in India. Again, in this judgment, reference was made to Animal Welfare Board of India versus Nagaraja, right? It's a very prominent case now. And reference too was made to this idea that animals have a right to live with dignity, right? So life doesn't just involve being merely alive. It involves having certain conditions or living in certain circumstances that are in accordance with your species needs. Court here found very interesting language that running the trade of birds is in violation of the rights of the birds. Right? It doesn't just say it violates the Animal Welfare Act or Anti-Cruelty Act. It says it violates the rights of the birds. They deserve sympathy. Nobody is caring as to whether they have been inflicting cruelty or not. Despite of settled law that birds have a fundamental right to fly and cannot be caged and will have to be set free in the sky. Right? So very interesting language here. It's a violation of the rights of the birds to be kept in these small cages. They have a fundamental right to fly, cannot be caged, and will have to be set free in the sky. Not only that, the court even considered to be settled law that this is so, right? Even though arguably this is a very striking finding that probably most people didn't think was settled law. The question this raises, well, did the court here recognize a sort of fundamental right to liberty for birds? The language certainly suggests it does. And indeed, it wasn't even the first court to recognize this. The Gujarat High Court in 2011 ruled very similarly. It said, with almost the same language, to keep the birds in the cages, this was also a case about birds having been kept in cages, would be illegal confinement of such birds against their wish, which would be against the fundamental rights of the birds to move freely. Right? So again, very similar language here. And the sort of the question the two judgments actually raise is, how serious is the court about its language of fundamental rights? This one even says fundamental right, not just right. Does it actually mean something like a human right to liberty? Or did it just use flowery language to talk about what may essentially be welfare protections for animals, right? Even in a welfare regime, you cannot keep a bird in, depending on the jurisdiction you're in cages that are too small. So does that mean that those welfare regimes recognize the fundamental rights of birds to be free and fly in the sky? Or did the court want to do more than that? Did they actually want to go beyond it? It's a question that, sadly, the court hasn't really resolved for us. It hasn't answered it, it has raised it because of language that is open to different interpretations. So, alas, we have to sort of leave the question mark there for now. Okay, so this was the first batch of cases on different types of fundamental rights going beyond just habeas corpus rights. I now want to turn to our second set of cases that go beyond habeas corpus, and that's the set of cases that deal specifically or with a particular focus on legal personhood in a way that perhaps other cases don't, or not to that extent. The first case that interests us is the case of Karnail Singh versus State of Haryana from 2019. This is again a case from India, and you can tell how, just judging by the number of cases from India, there's certainly a certain affinity toward animals there, not least due to the religion, the culture. What were the facts here of this case? The High Court of Punjab and Haryana had to deal with two trucks that were transporting cows, seemingly with the aim of crossing the border into Pakistan, I believe, with the probable aim of slaughtering the cows in Pakistan. Now, as you may know, India values cows very highly, and there is a law in the state of Punjab and Haryana. I'm not entirely sure if they're two separate states, but there's a law there which prohibits the slaughter of cows. And part of that law is also the protection, I think, of cows against being transported somewhere where they can be slaughtered. So in this instance, even though the slaughter would have taken place abroad where this law doesn't exist, the mere fact of transporting them or trying to transport them to such a place where they could be slaughtered would be in violation of the Prohibition of Cow Slaughter Act. In addition, the Federal Prevention of Cruelty to Animals Act, which we've already encountered now a few times, was invoked because of the transport conditions these animals were in on those two trucks. What did the court decide? Again, we're seeing a judgment that is somewhat similar to the K1 case in that it is very broad in what it does. It looks again into religious texts. It goes into environmental considerations about the relationship between animals and nature and humans. And a judge, after doing all of this, ruled that the state authorities must enforce anti-cruelty laws and laws protecting animals in transport. So it did find here that the two trucks, or people driving those trucks, had violated the respective provisions. But very interestingly for our purposes, the judge went on to say in the order, so at the very end of the judgment, the following: the entire animal kingdom, including avian and aquatic species, are declared as legal entities having a distinct persona. Legal entities having a distinct persona with corresponding rights and even duties and liabilities of a living person. All the citizens throughout the state of Haryana are hereby declared persons in loco parentis, so they would be acting as a type of guardian, as a human face for the welfare protection of animals. Now, again, this is all the information the court is giving us, right? And we have to interpret what this could mean. One potential way of interpreting this is to say, well, it seems like the court recognized that animals could be a type of sui generis legal person, right? I.e., they are a separate category of legal person, potentially. They have a distinct persona, right? Legal entities with a distinct persona that in many ways seems similar to other legal persons. So it says living persons, perhaps suggesting natural persons, human persons, rather than corporate persons. Very interestingly, the court even thought that duties and liabilities could apply to these animals. How would that work exactly? We don't know. The court doesn't tell us. It just leaves us with this very interesting sounding paragraph. Take another case. This is the case of Sandra from 2014. This case made the headlines when it was published. But unfortunately, most, if not all, journalists seem to misunderstand what happened in the case, partly because of translation issues, it turned out later. This was hyped as the first case in which an animal had been given fundamental rights and received sort of legal personhood protection. As we'll see in a second, it wasn't quite as good as this. So what were the facts of the case? Let's take a step back. In Argentina, and in fact in other Latin American countries, there's quite an active organization called the Association of Officials and Lawyers for Animal Rights. It's the sort of Latin American equivalent of the Non-Human Rights Project. In fact, this organization is older and already filed habeas corpus suits before the American Non-Human Rights Project even existed. Just as an aside. So they brought a suit here on behalf of Sandra, who you see on the picture here. Sandra was an orangutan who lived in a zoo in Buenos Aires. And the association here filed habeas corpus suits, as I just suggested, as well as amparo petitions, which I'm told is a particularly popular petition in Latin American countries, including in Spain itself, where it originated, which is a type of action that you can bring to have someone's rights recognized. It can be any type of fundamental right, if I'm not mistaken. So they tried to bring those two actions on behalf of Sandra, arguing specifically also that she's a legal person, because the idea was you have to be a legal person to have habeas corpus and amparo protection. The procedural history here is a really complex one, especially for people who don't understand the Argentinian legal system very well, such as myself and others. But we talked to some experts and we sort of tried to reconstruct the case history. So what happened was that there was a first ruling in 2014 by the National Chamber of Criminal and Correctional Appeals. Contrary to what the news reported, this court denied the habeas corpus petition. So Sandra wasn't actually granted habeas corpus. However, there was another court, the Federal Criminal Court of Appeals in the same year, which ruled that animals ought to be recognized as legal subjects because they hold rights. That seemed to be the reasoning. Perhaps the court was talking about thin rights. Maybe animals have thin rights and therefore they need to be recognized as legal subjects or legal persons. Or maybe they had something thicker in mind. Perhaps the most interesting judgment is this one here, which upheld the one I just mentioned. This is the judicial branch of the City of Buenos Aires, decision from 2015, which ruled that animals are rights-holding non-human persons. This is a judge called Elena Liberatori, the sort of liberator, it's quite a funny name for this judgment, who said, and this is the English translation from the Spanish original, that something along the lines of animals are subjects of law, they're subjects of rights. So maybe something like a legal subject, you might say. They're non-human legal subjects. The judge didn't, in this case, order the release of Sandra to a sanctuary, but she tasked a couple of experts with the decision. There was then on appeal another court dealing with the same case. And this court, contrasted to the previous two ones, held that this idea that animals are legal subjects is not a good one. We are revoking this part of the judgment. The only part we're upholding is the idea that Sandra's living conditions should be adequate. Right. It's also part of the previous ruling. So what we're left with here essentially is a situation where, if you like, the parts of the judgment that are interesting from an animal rights point of view were revoked. Right. The idea that Sandra could be a legal subject, a non-human person, that was revoked. What was upheld, on the other hand, was the more welfare aspects of the case, if you like. The fact that Sandra should be living in good conditions. Okay, this is the last case we will be talking about today. A case from the US. Justice versus Gwendolyn Bircher. Justice was a horse, or I think Justice may still be alive, depicted here in the photo. The Animal Legal Defense Fund, which you've already come across, a very active animal rights organization in the US, also active in litigation. They brought a strategic case in Oregon against Gwendolyn Bircher, who was the owner of Justice, the horse. And they tried to bring a tort suit rather than a sort of animal welfare act violation suit. And they said, well, Justice can be regarded as a victim of a tort, namely the tort of so-called negligence per se, which is a specific tort in the US. And the most important aspect of this tort for our purposes is that for you to be able to claim negligence per se or invoke negligence per se, you have to be a person who suffered an injury that a statute was designed to protect, so it has to have some legal basis in a statute, and that statute has to have been violated by the defendant. So here, of course, the obvious question that the court had to deal with was, well, can a horse be considered a person for the purposes of this tort? The Washington County Circuit Court, which dealt with the case in the first instance, decided that Justice, the horse, is not a person. It lacked standing here, and therefore the status as a plaintiff. And it added something that is now very familiar to us. It added that potentially animals could at some point be recognized as legal persons, but it's not the place of courts to do that, right? It's not the place of courts to recognize, declare animals as legal persons. It's someone else's role, presumably the legislature. This case is not over yet. It is currently on appeal before the Oregon Court of Appeals. The AODF specifically is arguing that, yes, justice is a legal person. He already has certain thin rights, and only persons can have rights, so therefore that suggests that justice might already be a legal person. So just recognize it, and then we can have this tort granted. That's their argument. And we'll have to see how this case will develop. Okay, let's conclude. So over the past two lectures, including Sean's lecture last week, we saw that most habeas corpus, most other fundamental rights suits, and indeed most legal personhood litigation has not been very successful. Right? It's not really a success story. So if you want to feel happy, you don't want to read the case law of animals' rights. However, there have been at least one or two cases that were successful, and probably the one that stands out is the Cecilia case we discussed last week, where a chimpanzee was actually granted habeas corpus protection and moved to a sanctuary. And the cases that have been successful, or at least if you take also the positive aspects of the cases that were less successful, they've been quite groundbreaking in what they're doing, right? So we're talking the first time that courts are recognizing that a non-human animal may have something akin to legal personhood, legal subjecthood, fundamental legal rights. So there are few cases, but they're groundbreaking in what they mean for the development of law on the whole. What we've seen is that at least some judges, perhaps many of them, seem to have been quite driven, or at least influenced by this idea that there is a dichotomy, or could be a dichotomy between humans who are persons and animals who are things. So perhaps some of them on a personal level might not have agreed with that, but they definitely saw that this is something that occupies the law, that determines the law, influences, shapes the law, and therefore also should influence their decision. So this dichotomy is still very much at play. We saw what could be seen as an issue, or potentially also as an upside, perhaps an advantage of some of these flowery judgments. Courts very often don't use precise terminology, which can be quite infuriating, for academics at least. I'm not sure if anyone else cares, but academics tend to get infuriated about imprecise terminology. Specifically, the use of legal rights. Well, it sounds very nice, but what do you mean? Do you mean welfare protection rights, which animals have in most jurisdictions, in 2/3 of all legal systems, as we saw? Or at least anti-cruelty welfare rights, if you like? Or do you mean something thicker? Do you mean fundamental rights? Because if so, we're really interested in what you're doing here. Can you please be a bit more precise? And now you might say, this is disadvantage, maybe it creates a lot of hype, but then if you look at the judgment closely, you'll see that actually it was just a welfare decision, potentially. Or you might say, no, this is actually a good thing, because even if perhaps at the end of the day the outcome was more of a welfare-based one, the language that was used opened the door. Right? It opened the door perhaps for future judges to say, look, there's already all these judges who recognize animals' fundamental rights, their dignity, the worth of their life, what have you, and even though maybe they haven't taken it to its logical conclusions, we could do that, right? So it could open the door for future judges. It could be a really good thing that they've adopted this flowery language. Depends on how you look at it. And then one last point that takes us back to a discussion we had last week also. Judges are quite conscious of the limited powers they have as judges, right? So you'll be familiar with this notion from sort of judicial review questions. How far can judges go, right? How much power do they have, and how much should they leave up to policy makers, to lawmakers? Some of these limitations may be self-imposed, as we discussed last week. It may be a convenient excuse for judges to say, well, my hands are tied. I'm sorry, I can't, decide that justice should be, eligible for this negligence per se tort. But at times it might, in fact, be a limitation imposed by the system, right? So there's potentially a bit of both here, these limitations. And there's the point that remains about if indeed they were to extend fundamental rights, depending on how you look at it, this might be quite a revolutionary, a momentous decision, and not everyone is willing to take that step. Indeed, as we've been finding out, most judges are not willing to take that step. Just as a last footnote, perhaps, this ties in now with the discussion that you'll see in some parts of scholarship which try to say, well, and we encountered this in our legal theory classes, you should stop presenting this as a revolutionary thing. If you look at it as a sort of more thin rights given to animals, perhaps more expansive rights, but they already have a pile of rights, they're just thin rights, then it stops being a sort of a momentous step for judges. It stops being something scary. So maybe it would be better if we presented things more in the language of thin rights, rather than talking about these huge fundamental rights that are now potentially being given to another class of beings entirely. So that's where the sort of this debate about which language should we use, which concepts should we use, becomes important again, because it could potentially sway judges in favor of doing something that would benefit animals. Okay, I'll end here, and I'll look forward to any questions or comments you may have.